Hello friends, my name is Neil Kamal and I am currently working as a senior public prosecutor in National Investigation Agency and posted at NIA headquarter New Delhi. So we will today discuss about the history and evolution of anti-terror legislation in India. The first counter-terror legislation in India is Terrorist and Disruptive Activities Act 1985, and after that we have POTA Prevention of Terrorism Act 2002 and the current legislation which is Unlawful Activities Prevention Act 1967. In the TADA was enacted on experimental basis for a period of 2 years in the year 1985, and it was given extension from time to time. It remained in force until 1995. The constitutionality of the TADA was challenged before the Supreme Court in Kartar Singh versus State of Punjab 1995, where the Supreme Court upheld its constitutional validity. However, asked the government to put certain restrictions to avoid misuse of the stringent provisions of the law. So, under TADA, terrorist activity was defined. Certain new offences like harboring an offender, member of a terrorist organization, and special designated courts were constituted. Thereafter, the law was repealed in the year 1995, but due to certain terrorist activities like attack on World Trade Center in the year 2001, Parliament attack in India, and hijacking of Air India flight IC 814 in 1999 to Kandahar. These incidents forced government to enact anti-terror legislation. The POTA was brought into force and it remained valid and up to year 2004. In 2004, Unlawful Activities Prevention Act was enacted. The act is of 1967, but in the year 2004, chapters relating to terrorism were incorporated in it. Chapter 4, Chapter 6, which deal with terrorist act, terrorist organization, terrorist gangs, terror funding. If we see compare TADA, POTA, and UAPA, the common features are: first, terrorist act. Terrorist act is defined under all the three acts. However, certain modifications were made from time to time. Second, bail provisions were stringent. Like currently UAPA under section 43D provides that no court shall grant bail to the accused if after perusal of the case diary and the report under 173 CRPC, that is charge sheet, and after hearing the public prosecutor, if court is of the opinion that the accusation against the accused is prima facie true. So stringent bail conditions, bail laws were incorporated under the anti-terror legislations. Another thing is the detention and the period of investigation. Enlarged period of detention of the accused is provided under all these three laws. Like under ordinary law, the police custody can be obtained up to 30 days. However, under police custody under the ordinary law can be obtained up to 15 days. However, under the UAPA, the police custody can be obtained up to 30 days. and the period of investigation is extendable up to 180 days. Although under ordinary law, IPC or BNS, the maximum period of investigation is 90 days. Another thing is about the courts. Designated courts are provided to try these offences under the special legislations. So currently we have section 11, section 22 of the NI Act, which provides that designated courts to be established to try the anti-terror offences. So mainly these are the provisions. Another thing is review committee. Provisions of review committee is there under the there is no provision for review committee under the TADA. Under the POTA, there is a provision for review committee to see whether the proceedings under the Act can be instituted against a particular person or not. Under the UAPA, we have a provision for review committee, but its function is to notify or denotify the terrorist organizations or the individuals that are mentioned in the first and the fourth schedule. Other important provision is regarding presumptions. If the arms and explosives are recovered from the accused, and there is evidence like forensic evidence or some other evidence which shows the linkage of the accused to the scene of crime, then the court shall presume that the accused has committed the offense. So broadly, these are the main provisions which are there in all the three acts if we compare and go through the history of the counter-terror legislation in India. In another part, we will discuss in detail the Unlawful Activities Prevention Act. Thank you.